Your Honour, my name is Colley, C-O-L-L-E-Y, initial H, and I appear with my junior Caitlin, C-A-T-L-I-N, initial R, for the defendant, Midnight Garden, in this matter. The defendant presents 4 main submissions. These are duty of care, breach of duty, causation, and remoteness of damages. I will be dealing with the first 2 of these submissions, and my junior will present the second 2. I will now move on to my first submission, duty of care. A duty of care arises in circumstances where it can be reasonably foreseen that an act or an omission would likely cause injury to another person. Where a duty of care arises, the person who owes the duty must perform that duty or must act to a reasonable standard. Proprietor Robert Sheen took all reasonable steps in his duty of care to remove the offender from the premises. Care was not only shown by removing the offender from the premises, but Robert went above his duty and tried to arrange transport for the offender. Our second submission is breach of duty. Your Honour, we ask, has the standard of care expected of the defendant in the circumstances been breached? The offence was not foreseeable and happened outside Midnight Garden's area of responsibility. There can be no fault element, as the proprietor acted within all reasonableness to show duty of care to patrons of the eatery by removing the offender. The plaintiff cannot show that the duty was violated by the defendant because they took all reasonable steps to protect the safety of all those at Midnight Garden. I will also point to the legislation requirement of the Civil Liability Act. Section 9(1) provides that a person is not in breach of their duty of care unless the risk was foreseeable, the risk was not insignificant, and in the circumstances a reasonable person in the position of the person would have taken the precautions, such as in the case United States v. Carroll Towing. It was held, if a risk is foreseeable, the court has to then consider what a reasonable person's response to that risk would be, as per Section 9(1)(c) of the CLA. We find Midnight Garden could not have foreseen the assault happening, and especially could not have controlled what happened outside their area of responsibility in a secluded car park. The court must consider all of the factors which would influence a reasonable person determining whether or not to take precautions to avoid the risk. These factors are the probability of the risk materializing, which in this case could not have been foreseen as the offenders were removed and not permitted to return. The proprietor of Midnight Garden had no issues with removing them, and they left without a struggle. The gravity of harm, as it materialized, was not an expected outcome and could not have been foreseen. The harm happened in a private and secluded car park away from the premise, and the harm could not have been expected. The defendant did not owe a duty of care to patrons outside the premises. Social utility was justifiable by Midnight Garden's conduct. The defendant did what any reasonable entity would do by removing the offender. The defendant did not breach its duty of care by failing to ensure the offenders had left the area and by ensuring the plaintiff was safely escorted to his car. This is out of the scope of responsibility, and the risk was not foreseeable as per Section 9(1) of the Civil Liability Act. The defendant did not breach its duty of care by failing to provide a security guard on the Sunday evening, as per exemptions to employing security at licensed premises. Restaurants holding a commercial license with the principal activity of providing meals are exempt from employing security providers in accordance with the ratio. The principal activity of a restaurant is not the sale of alcohol, and there is little evidence that restaurants significantly contribute to alcohol-related violence. It is not the standard practice for the police to be called in such incidents, and therefore Midnight Garden did not owe a duty to the plaintiff to have called the police. Your Honour, I would like to point the court to similar cases in which the duty of care was not found to be breached, and why. Adil's Palace v. Mubarak, In this case, the High Court of Australia overturned the decision to award damages for 2 injured men who were both shot in the appellant's restaurant. The 2 men had brought proceedings alleging that they suffered injuries as a result of the appellant's negligence in not providing sufficient security at the function. It was held that the negligence found against the appellants was not demonstrated to have been the cause of the men's injuries. The conclusion that the presence of security personnel would have deterred the re-entry could not be found. The absence of security personnel was not a necessary condition of the occurrence of harm, and the New South Wales Civil Liability Act 2002, Section 5D1 was not satisfied. Another significant case was Mudbury Triangle Shopping Centre versus Anzil, where the respondent was assaulted while in a car park owned by the appellant. The landlord had been requested to keep the lights on after 10 p.m. but had refused. It was held that the existence of foreseeable risk is not sufficient to impose a duty to take reasonable care to prevent harm to somebody lawfully on land for criminal behaviour of a third party, and the appellant did not have a duty to take reasonable care to prevent physical injury. Your Honour, I therefore conclude the defendant Midnight Garden was not in breach of its duty to take care, and the standard of care taken is what is expected of a reasonable person or entity in the circumstances. We find no elements of negligence were met. Your Honour, I will now hand over to my junior who will speak on our remaining submissions.